Thank you for the record. The name is pronounced Szybist. Mark Szybist is the name. I'm a staff attorney for Citizens for Pennsylvania's Future, or Penn Future. I work out of the Wilkes-Barre office. I'm also on the board of directors of the Responsible Drilling Alliance, or RDA, which is based here in Williamsport. I'm speaking tonight on behalf of Penn Future. First, I'd like to thank you all for the opportunity to comment and for all the hard work that obviously went into this rulemaking. The rulemaking runs to 74 pages, so 5 minutes is not a lot of time to comment. And for that reason, Penn Future will be submitting detailed comments on the particular provisions of these regulations. Tonight, in the 4 minutes or so that are remaining to me, I'd like to do 2 things. First, because I'm the first person speaking, I'd like to kind of place this rulemaking in a larger legal context, as much for the benefit as the rest of the people here, as for the board, and then I'd like to offer a couple of particular comments. First, by way of context, as most people in the audience know tonight, on the federal level, oil and gas operators are exempt from important sections of many important federal laws. Hydraulic fracturing is exempt from the Underground Injection Control Program under the Safe Drinking Water Act. Oil and gas stormwater discharges are exempted from NPDES permit requirements under the Clean Water Act. Most oil and gas wastes are exempt from regulations hazardous waste under the Resource Conservation and Recovery Act. As a result, the DP has to rely largely on state law to regulate oil and gas drilling operations. And the main state law, of course, is Act 13, has been pointed out. Now, as many folks here know tonight, Act 13 is problematic in many respects. In December, the Pennsylvania Supreme Court struck down important sections of the law as unconstitutional. But there are other laws, too, that DEP uses to regulate oil and gas operations, including the Pennsylvania Clean Streams Law, the Solid Waste Management Act, and together, these and other laws give the DEP significant power to protect public health and the environment and to make some of the bad features of Act 13 less bad. One example is bonding. Act 13 sets particular requirements for bonds for oil and gas well operators. The DEP and EQB cannot, by regulation, increase the amounts of those bonds, but the DEP can establish processes to make sure that well sites are not released from bonds until they are adequately restored. Now, in many respects, the DEP is to be commended for the proposed regulations in this rulemaking. For example, Penn Future supports proposed water quality requirements in Section 78.51 concerning the replacement of water supplies affected by gas drilling. We also support the DEP's decision to promulgate regulations for the first time for above-ground pipelines carrying gas well wastewater, for freshwater impoundments, for horizontal directional drilling for oil and gas pipelines, and for borrow pits. However, there are many particular problems with the regulations. I mentioned bonding, and that's a problem. Subchapter G of the proposed regulations does not ensure that well sites will be adequately restored before they're released from the bond. As far as we can tell, the release turns on the filing of a certificate of a plugging only. Release from liability should also be conditioned on a demonstration that the well site or impoundment site is adequately restored after the last well has been plugged. I'll speak a little more particularly to restoration. Act 13 requires 2 stages of restoration for well sites. By the way, will somebody let me know when my time is almost going to be done? Okay, thank you.
We'll let you know when there's a minute up.
Okay, thank you. Act 13 requires 2 stages of restoration for well sites. On the one hand, Section 3216C requires partial restoration after the conclusion of drilling and fracturing operations. Section 3216D requires final restoration after the last well on a site's been plugged. The DE is proposing to implement these sections in proposed Regulation 78.65, which provides that a well site will be considered restored if it's returned to its approximate original contours, including pre-construction contours, and if it can support the original land uses to the extent practical. Similar language appears in the DEP's proposed regulations for freshwater impoundments and centralized wastewater impoundments, which also contain restoration requirements. A return to original conditions, contours, and uses is a commendable goal for the restoration of well sites, both post-drilling and post-plugging, and impoundment sites. However, the DEP's general restoration standards are now practically unenforceable because they fail to require environmental baseline site assessments, they fail to require site-specific standards and criteria for restoration, they fail to require environmental professionals to sign off on site restorations, and they establish no process whereby the DEP can finally approve or disapprove restoration. The DEP should require site-specific baseline assessments and restoration plans for all well and impoundment sites, should require professional certification that restoration goals have been met, and should require DEP approval before a well site can be considered restored. One final thing, Penn Future was among several groups that requested that the EQB extend the comment period for these regulations and include hearings in places like Bradford County and Butler County, which have large development but currently have no hearings. We repeat that comment here. Thank you very much.
Did you leave comments there?
I just have notes. We're going to be submitting detailed written comments, so we'll provide something right away.